Good morning and welcome to the North Carolina Court of Appeals. We have three cases for argument, two of which have been consolidated in Duke Energy versus the public staff. I am Judge John Arrowood. To my right is Judge Jefferson Griffin. To my left is Judge Michael Statting. We will be your panel for the arguments today. We'll take a short break in between the two cases and be at ease for a moment as we reset the courtroom. But we are ready to hear from the appellants in the first case.
May it please the court. My name is Will Freeman, and with me is Zeke Creech. We are attorneys with the public staff, which is an independent agency tasked with representing the interests of the using and consuming public in matters that come before the North Carolina Utilities Commission. I would respectfully request to reserve 10 minutes of my time for rebuttal.
Okay.
Thank you. Your honors, for decades, Duke Energy, the commission, and the public staff all had the same understanding of the straightforward language of the fuel rider statute, that it only allowed for recovery of fuel costs, quote, incurred during the test period. The test period for these proceedings was calendar year 2023 for Duke Energy Carolinas and April 1st, 2023 through March 31st, 2024 for Duke Energy Progress. So just for ease of discussion, I'll refer to these as the 2023 fuel costs. The proceedings before you today were brought in 2024. There was no issue with reasonableness or prudency of the fuel costs. Therefore, under the fuel rider statute, Duke Energy was entitled to recover the difference in its forecasted 2023 fuel cost expenses versus its actual 2023 fuel cost expenses for those fuel costs that were, quote, incurred during 2023. This is the true-up, sometimes called the experience modification factor, sometimes EMF. That's at the heart of this appeal. The public staff appealed because Duke Energy requested and the commission allowed rates designed to recover fuel costs incurred in 2022. Not to put too fine a point on it, but the fuel costs were incurred before 2023, not during 2023. The Thornburg case from 1987 teaches that any utility's request to recoup past under-recovery of fuel costs is prohibited as impermissible retroactive rate making in the absence of a manifest and unambiguous specific statutory language to the contrary. The fuel costs incurred during 2022 were addressed in the fuel rider proceedings and the ones right before the ones under appeal. Those fuel costs were completely addressed in those prior proceedings. Those rates were not provisional. No door was left open. No party appealed those proceedings, the ones immediately before the ones under appeal.
What they did in fact not address, Duke was not able to recover all of their 22 costs on the previous order. Is that correct? Is that why we're here to some extent?
Correct. Duke had an under-recovery for DEC and DEP, the two consolidated cases. One was approximately $9 million. The other was approximately $15 million. Your Honor, just recall traditional rate making is a prospective exercise. It's akin to budgeting next year's expenses informed by last year's expenses. It's a matter of estimation and prediction. The commission does not guarantee dollar-for-dollar recovery. It only guarantees an opportunity for recovery. Just to consider like a very simplified example, if an electric utility's forecasted revenue needed is $100 and its forecasted electric sales are 100 megawatts, the commission may very well allow rates at $1 per megawatt hour. And so if there are sales of 102 megawatts, the utility profits $2. And if the expenses unexpectedly increase to 101, the utility loses $1. It's the same as any company in the private sector. If Coca-Cola sells more Coke, they make more money, right? fuel expenses were such a large part of utility sort of overall operating expenses and really volatile in the late 70s. We had the oil embargo. The General Assembly and Commission created an exception, the fuel rider proceeding. And in the original iteration of the fuel rider proceeding, rather than go through the complicated rate-making process, you could have this more streamlined process just addressed to fuel, where you forecasted your fuel expenses next year and you put those into rates now. And so what happened in 1985 was CP&L, which is the predecessor to Duke Energy Progress, had a under-recovery, came before the commission and said, hey, our forecast was so off that we have a large under-recovery. And the commission wrestled with it, but at the end said, okay, we'll give you 90% of the difference in your forecasted expenses versus your actuals. And the public staff and attorney general appealed. That would ultimately lead to the Thornburg case. But before Thornburg came out, the commission issued an order and promulgated Rule R855 regarding this, what was then a new idea, this true-up. The EMF is what it called it. And that order and rule are in our appendix at page 14 to address the concerns that estimates wouldn't matter anymore since we now have this true-up. The commission stated there would still be incentives for accurate true-ups to avoid the potential cascading effect of unintentional but nevertheless systematic over or under collection of reasonable and prudently incurred fuel costs. There would never be this risk of cascading under or over collections if Duke Energy's interpretation of the law is correct. They would just true it up every year. It would be a rolling true-up, not a one-time, one-year true-up. And in 1986, the commission took a long view and said, the EMF will minimize and over time eliminate cumulative under and over collection of reasonable and prudently incurred fuel costs. And that's what happened since 1987. Many years Duke has under-earned. Many years Duke has over-earned. We put a chart at page 23 of our brief which shows different years. Just as today we're challenging Duke's attempt to recoup an under-earning, had the public staff come in those years when Duke over-earned millions, this court would have been justified in saying, nope, that's also prohibited retroactive rate making. That's also precluded. Some years are up, some years are down. Over time, it will even out. And over the decade or so that's in the chart, even though you have hundreds of millions of dollars flowing through these riders, it comes within like $2 million, $3 million net when you net them all out. So I think that in 1986, the long view was the correct view. So after that 1986 commission order, Thornburg came down. That's the decision I just discussed. The Thornburg court searched the statute for specific language allowing recoupment of past fuel costs, and Thornburg said the General Assembly is aware of the judicial prohibition against retroactive rate making, and therefore it is doubtful that the General Assembly would have intentionally modified or overruled established judicial decisions without language that made its intent manifest and unambiguous. And so the General Assembly took up the Thornburg offer to make its intent manifest and unambiguous and passed the 1987 Session Law 677. But again, remember this true-up is kind of a new idea, so the General Assembly limited it to a one-time, one-year look-back period, a one-time true-up, by restricting the recoupment to a comparison between the forecasted fuel costs to the actual fuel cost, quote, incurred during the test period. So that's that Session Law from 1987, Session Law 677. And I think the Commission and Duke Energy heavily relied on Section 2 of that Session Law in saying, hey, that Section 2 does indicate the sufficiently manifest and unambiguous language that does allow retroactive rate making. The Commission spent a lot of its decision kind of analyzing Section 2. And so I would, apart from the decades of prior practice of the contract, I would point to three things about this Section 2. First, Section 2 is one sentence. It's one concept. And the first part of that sentence explicitly endorsed the Commission's prior position because the General Assembly stated it was clarifying prior law quote, as construed by the Utilities Commission in Commission Rule R855. That's the rule I just spent a few minutes discussing with the court. So the General Assembly statement, there should be no under or over recovery, is part of the same sentence endorsing the Commission's interpretation, which made clear that poor estimates could result in cascading over and under collections, and that over time, a utility would have no under or over recovery, have a chance to eliminate it. The second point I would make regarding Section 2, statutory construction rules tell us that where there's a sort of general expression and overarching goal, and then there are these specific sub-items, the specific provisions control. The specifics are the path to reach the stated goal. And therefore, subsection D of the Fuel Rider Statute is the mechanism for achieving the goals expressed in Section 2. The third point regarding Section 2, the session law was enacted in 1987 and was not codified. It is law. It was read aloud in General Assembly. It is law. It was signed by the governor. But it was not codified, and it does not get repeated. It does not appear in subsequent laws. Between 1987 and this summer, more than like half a dozen times the Fuel Rider Statute was touched by the General Assembly, including in 2007 when Senate Bill 3 altered the very sentence that's at the heart of this appeal, and it changed fuel costs to the cost of fuel and fuel-related costs. This is the exact sentence we've spent this case discussing. At no point in all these decades did the General Assembly indicated there should be a change in the Commission's practice of having a one-time, one-year look-back period, this one-year true-up, until the summer of 2025, when the General Assembly did make a change, and a substantial change. In July 29th, the General Assembly made a very surgical alteration to the Fuel Rider Statute and deleted the one-year limitation, the one-year true-up, the one-year look-back. It deleted incurred during the test period and replaced it with incurred. And it just allows recovery now of all fuel costs incurred. So in making that change, the General Assembly specifically called it a modification of, quote, the statutes governing cost recovery for fuel-related charges. This is not a minor clarification, a tweak or refinement. If Duke's interpretation is correct, there would have been no need for this law, much less a wholesale refinement, a wholesale modification of this law. And I don't think we should presume that the General Assembly's actions are without effect here. I think the General Assembly knew it was changing the law and gives us that information by putting in the title of the law that it's making a modification and a change. Sorry, change does not appear in the title, making a modification to the statutes governing cost recovery of fuel-related charges.
Now, if you say that they made a modification, which is a change in how does that affect this particular case? If we agree with you that it's not a clarification, but it's a modification, how does that affect the ability of Duke to go back in the future and collect these funds that we've spent a lot of trees arguing about in this case?
Well, respectfully, Your Honor, I think you're sort of thinking, should this law apply retroactively or not? I think it's sort of maybe at the heart of the question.
Well, that is at the heart of the question, but
and I'm not trying to, I just want to make sure I understand what the court's asking. Neither party has briefed that issue, but I will say this law was effective July 29th, 2025 by its own terms, and there is quite a large body of case law about when laws are retroactively applied. More than 100 years ago, the Hicks Court said every reasonable doubt is resolved against a retroactive operation of a statute. And as I read the case law, if you have an obligation that's become fixed and certain, I might say incurred, to use the language of the Fuel Rider Statute, then retroactive application of the law is inappropriate. But I want to note that this was an area of strong disagreement between the public staff and Duke Energy Carolinas, and Duke Energy Progress, I apologize. And in the fuel rider proceeding after the ones under appeal, docket number E2 sub 1358, which we identified in our memorandum of additional authorities filed on December 15th, 2025. In that order, the commission addressed this retroactive application, and they landed on I would characterize it as a partial retroactive application of the law. So I would say that the decision here today is not moot for the reason, first off, the law's effective date is July 29th, and these cases were well before that, so the decision here is not going to not matter. The system put in place by the General Assembly changed for fuel costs incurred on or after 10:03 a.m. July 29th, 2025. And so up until that point, we would still apply the language of this fuel rider statute. If there are, I don't want to rush the court, of course. If there are no further questions.
I may have another one based upon your last argument, but I'll do that in your rebuttal.
The public staff respectfully request the court find it was an error of law to allow rates permitting recovery of fuel costs incurred prior to the test period, and further respectfully request the court reverse and remand these two fuel rider proceedings to the commission to effectuate a return of these funds to customers. And I would request that the balance of my time be reserved for rebuttal. Thank you, Your Honor.
That's fine. And my question is going to be to you, because we do have to get into whether we need to get into the retroactive effect, because the last thing you ask us to do in your brief is to order a refund to be issued to the customers. And don't we have to consider the new session law and the retroactivity if we get to there? But I'll let you answer that in your rebuttal question.
Thank you, Your Honor.
Good morning, Your Honors. Jonathan Ellis with McGuire Woods, here on behalf of Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC. I have with me Jack Dirac of Duke Energy. As an electric public utility, Duke rates are regulated and fixed by the Utilities Commission. Broadly speaking, those rates are made up of two components: base rates and riders. Now, base rates are established through general rate cases. Those are complex, time-consuming, and expensive proceedings that comprehensively examine the utility's financials, its capital, its operating expenses, its reasonable return. General rate cases are forward-looking. The Commission considers past costs and expenses to inform future rates, but it does not attempt to correct any over-recovery or under-recovery, as my friend pointed out this morning. By contrast, riders are set through more frequent, streamlined proceedings that focus on just one aspect of a utility's costs on which they do not earn a return. Those proceedings adopt increments and decrements to the utility's base rates to reflect whatever changes in that cost. That
are there any services or expenses besides fuel that are included as riders?
There are, yes. There are a handful of riders that North Carolina adopts, and our riders is not something that's specific to North Carolina law. They're adopted sort of all across the country to focus on these costs that tend to be more volatile than others. Fuel costs in particular, as public staff mentioned this morning, tend to make up a substantial portion of the utility's expenses. They tend to be volatile, and they are outside of the utility's control largely, and that's what riders generally
are there any other riders in North Carolina that are analogous to the fuel rider or statute there?
So there are some other expenses. There's one about joint asset recovery that is actually be before this court soon. Also allow for true up of those costs. Yes, there are different expenses across where they have more frequent, these streamlined proceedings that allow the commission to then address just one aspect of the rates and then increment or decrement the base rates to account for changes. In 1987, in the Thornburg case that we already talked about this morning, the court held that under a prior version of 62-133.2, that the fuel rider proceeding, like the general rate case, was exclusively forward-looking. Although the General Assembly had directed the Commission to consider both fuel costs and the recovery during a prior test period, this court held that they did so only to inform future rates, not to allow for a correction of an over or under recovery of those fuel costs. My friend public staff rests heavily on that court's decision. I think what's important is that quickly after that decision, the General Assembly disagreed. Within months of this court's decision in Thornburg, the General Assembly amended the law to clarify that fuel rider proceedings are in fact designed to correct any over-recovery or under-recovery in prudently incurred fuel costs, that true up those costs. And so I think the question for the court this morning is whether when they made that amendment in 1987, they intended to provide dollar-for-dollar recovery of those costs as we submit and the Commission adopted, or they allowed for a one-time chance to true up those costs as the public staff argues. The consequences of that question are stark. If you just consider just one of the utilities before the court this morning, take DEP, in their 2023 fuel rider proceeding, not the one at issue here, but the one before, they showed the Commission, and the Commission found that their fuel costs for 2022, although reasonable and prudent, were under-collected by their 2022 rates by amount of $445 million. The Commission found in that proceeding, therefore, that they were allowed to correct for that under-recovery and set the fuel rider accordingly, and no party appealed. Nevertheless, during the following billing period, actual customer usage and demand resulted in another under-recovery. This time, as Judge Airwood noted earlier, $9.2 million of that $445 million had still not been recovered. Now, had winter been a little colder than, instead of a little milder as it was that year, it could well have been an over-recovery of a similar amount. In the proceedings below, a unanimous bipartisan commission determined that the best reading of North Carolina law authorizes the Commission to correct for such under or over recoveries. If the EMF component of a fuel rider, through no fault of the utility, leads to an under recovery of prudently incurred fuel costs, the utility should be permitted to correct that under recovery through the next year's rider. Conversely, and importantly, if the EMF rider component of a fuel rider leads to an over recovery of prudently incurred fuel costs, consumers are entitled to a refund with interest through the next year's rider. In other words, for every dollar of prudently incurred fuel costs, the EMF entitles Duke to $1 of recovery, no more and no less. In its briefs and in argument this morning, the public staff disagrees with this common sense approach. But the Commission's reading of Section 62-133.2 is most consistent with its plain text, most consistent with its context and history, and most consistent with the General Assembly's most recent amendment to the provision in SB 266. It's a sensible and equitable policy for North Carolina utilities and for their customers, and it's the one that best reflects the General Assembly's intent. I'm happy to address, of course, any of the court's questions this morning, but barring that, I plan to address first the text of the statute, the context and history, and then the most recent amendment, and may add a few words if I have time in response to some of the public staff's arguments. To begin with the plain text, if you don't have it in front of you, I'm going to walk through it. Feel free to bring it up as it's at page 4 of the public staff's appendix. The key sentence provides that in an annual fuel rider proceeding, the Commission shall incorporate into its fuel cost determination the experienced over-recovery or under-recovery of fuel costs, quote, during the test period. And that's where the disagreement lies. The public staff argues that the phrase during the test period describes when the fuel costs must have been prudently incurred. So if the fuel costs were incurred before the test period, the utility can't recover them, even if they have not yet recovered them through any other means. And if there's an over-recovery of fuel costs before the test period, then the utility keeps it, and there's no refund to the consumers. Under their view, an over-recovery is a windfall, and an under-recovery just the cost of doing business. But that view is wrong. In our view, the phrase during the test period describes when the over-recovery or under-recovery was experienced not when the fuel costs were incurred. During the test period describes when the over-recovery or under-recovery was experienced, not when the fuel costs were incurred. And so the annual fuel rider should account for any over-recovery or under-recovery that occurs during the test period, regardless of when the fuel costs were prudently incurred.
So under your interpretation of the statute as it was read at that time, you could have gone back to 2020 or 2021 or you could go back an infinite period of time to recover.
So this is an important point. In our view, it's not, the public staff says we're reading the during the test period phrase out of the statute, and that's not how we see it. During the test period is doing work, but it describes and limits when the over-recovery or under-recovery occurred. So if there was an over-recovery or under-recovery of fuel costs that occurred during the test period, then we don't look at it doesn't matter when the fuel costs themselves were prudently incurred. So it might help to take an example. If you look at the DEC proceeding that's at issue here, there was for them, they actually had the 22 rates led to a $998 million under-recovery. And so the EMF component of the fuel rider was then set to allow to recover for that. It didn't, just like in both proceedings here, the EMF component of the fuel rider didn't fully recover that under-recovery. What we said to the commission was we think it's going to come up about $17 million short. But because of a settlement, because the fuel rider in the DEC proceeding was actually extended over 16 months instead of 12, we said, well, only $8 million of that is of that under-recovery of the under-recovery costs is going to occur during the test period. So that's what we asked the commission to allow us to address in this proceeding. The $8 million of under-recovery that occurred during the test period, and the rest of that portion, the rest of the $17 million that we didn't recover from that EMF component, we'll recover in the 2025 proceeding. The point is, during the test period is doing work here. It limits, under either side's view and the commission's view, it's just what does it limit. We think it limits the over or under recovery when it was experienced, not when the fuel costs were incurred. I think there are 3 textual indicators in section 62133.2D itself that show that we're right about that. The first is the use of prudently incurred throughout that section. It appears about 4 times, I think. Every time it's talking about how the fuel costs were incurred, not when. And what it describes are recoverable fuel costs. So if you're looking at the key provision at issue here, there's a very long phrase right in the middle. Fuel costs and related costs of fuel expenses prudently incurred. That whole phrase can just be replaced with recoverable fuel costs. That's what that describes. Then you've got a sentence that says the commission should take account of any experienced under recovery or over recovery of recoverable fuel costs during the test period. That, I think, is much more naturally read our way, that during the test period talks about when the over recovery or under recovery was experienced. The second textual indicator is the very next sentence. This is a supplemental update provision. Supplemental updates allow a utility to capture or account for over-recoveries and under-recoveries that occur outside the test period up to 30 days, calendar days, before the hearing, the fuel rider hearing. What the statute says, and this is key, is that upon the request of the utility, the commission shall incorporate into its fuel cost determination, same as the sentence before, the experienced over-recovery or under-recovery of fuel costs through the date that is 30 calendar days prior to the date of the hearing. Now, what's important grammatically about that sentence is that the phrase prudently incurred doesn't appear at all. The reason for that is because fuel costs that are captured in a supplemental update have their prudence tested in the next year's annual fuel rider proceeding. But what the absence of that phrase shows is that the time limit in that provision, up to 30 days before the hearing, cannot possibly describe when the fuel costs were prudently incurred because the phrase doesn't appear. Instead, what that timing talks about is when the over-recovery or under-recovery occurred. So a supplemental update can account for over-recoveries or under-recoveries that occur up to 30 days before the hearing. Grammatically, it makes no sense for that provision, for the time limit in that provision, to describe when the over-recovery or under-recovery occurred, but in the sentence before, the parallel time limit during the test period, to describe something else, to describe when the fuel costs were incurred. That's not how writers write. Substantively, it makes no sense, because if a utility can then request for an over-recovery or under-recovery to be accounted for through a supplemental update provision, regardless of when the fuel costs were incurred, then why would you limit that in the initial determination? The utility could just ask for the very same over-recovery or under-recovery to be accounted for through a supplemental update, even if the commission couldn't do it in its initial determination. The third textual indicator is one other instance of prudently incurred. It's in section 62133.2d. That, just a couple sentences down from the key provision at issue, the commission is directed to account only for fuel costs that were, quote, prudently incurred under efficient management and economic operations. There is, in that sentence, no time limit at all, because when fuel costs are incurred, for fuel costs to be incurred, recoverable, they must have been incurred reasonably and prudently, but not at any particular time. Now, we think those textual aspects within just 62133.2d make clear that we have the better of the reading and that the commission was right. But if you have any doubt about that, we do point the court to a number of other things in the context and history, most importantly, Section 2 of the 1987 amendment. Section 1 of that amendment, as we've discussed this morning, is the one that clarified that the EMF component should be available. The true-up mechanism should be available, and always was. It's the one that disagreed with Thornburg. The whole session law is in DEC record, pages 734 to 736. It's very short. The very next section is the one I'm talking about now, and here's what it says. The enactment of this act shall be construed as clarifying rather than changing the meaning of section 62133.2, as it was previously worded and as construed by the Utilities Commission in Rule R855, so that electric utilities will recover only their reasonable fuel expenses prudently incurred. And here's the most important part, with no over-recovery or under-recovery in a manner that will serve the public interest. If the court had any doubt about whether the 1987 amendment was intended to provide true dollar-for-dollar recovery, not this one shot, that clear statement by the General Assembly should remove it. The Commission relied heavily on that provision in the orders before the court, and we think the court should do the same. Section 2 is enacted law by the General Assembly, as my friend acknowledged this morning, and although it wasn't codified, the Supreme Court has told us multiple times that such enacted language from session laws is controlling. Contrary to my friend's assertion in the briefs that principle is not limited to Scrivener's errors, I'd point the court specifically to the very first case we cite for this proposition, custom molding. It is really on all fours with this one. There, the court relied on an uncodified provision of a session law, stating that an amendment to interest on breach of contract awards should not be read to modify pre-amendment law on post-judgment interest. The court honored that intent in its decision, even though the codified text was not limited to pre-judgment interest. And absent the uncodified text, absent the uncodified statement of the General Assembly's intent, it surely would have been read to affect both post-judgment interest and pre-judgment interest. In Cohane, the Supreme Court relied on an uncodified portion of the Safe Child Act to find that the claims before it were revived, time-barred claims were revived, even though the codified text would surely have barred those claims. Applying Section 2 in this dispute requires affirming the Commission's orders. The only way to read Section 62133.2d to ensure no over-recovery or under-recovery is to adopt the Commission's approach. The ability for a fuel runner to true up previous under-recoveries or over-recoveries depends on forecasts. And as these proceedings well demonstrate, because neither utilities nor the Commission are clairvoyant, relying on forecasts of customers' electric usage or projected fuel usage will inevitably lead to more under-recoveries, further under-recoveries or over-recoveries. And only wishful thinking by the public staff supports the idea that those over-recoveries or under-recoveries will cancel each other out over time. The Commission's approach is the only one that allows for dollar-for-dollar recovery, no more and no less. There are several other indications in the history and the context I think support our view. We talked about a little bit already, the Commission's rule, R855. It predates the 1987 amendment, and it is more consistent with the Commission's approach than the public staff's. You can find that on appendix page 7 of the public staff's brief. Subsection D3 of that rule addresses the same, it's kind of the parallel one to the key provision of the statute that's at issue this morning, but it is a bit different in a way that I think is meaningful. That section says that it's the fuel-related revenues that must have been, quote, actually realized during the test period. So it just flips the order. First, it says you look at the difference between the prudently incurred fuel costs and the fuel-related revenues actually realized during the test period. But when you flip the order, it makes clear that what we're talking about, what has to have occurred during the test period, are the fuel-related revenues. That is, that's what makes an over-recovery or under-recovery. So I think that rule is more consistent with our view, and importantly, it's not just a rule by the Commission, it's a rule that predates the 1987 amendment, and a rule that was expressly endorsed by the legislature in Section 2 of the 1987 amendment. The 1986 rulemaking order that adopted that rule, that was also endorsed by the General Assembly, likewise supports our view. Like Section 2, and my friend read from this morning, the rulemaking order emphasizes repeatedly that the Commission's approach is designed to permit utilities to minimize, and here's the important part, over time eliminate the over or under collection of reasonable and prudently incurred fuel costs. Now, my friend spoke to another quote from that rulemaking order this morning about cascading under recoveries. That's in a section of the rulemaking order that talks about why adopting the EMF component is not going to eliminate the incentive for utilities or the Commission to be as accurate as possible with their fuel costs and their fuel rider. What it says is that there's inevitably a delay between collecting the fuel costs through an EMF as opposed to in the first instance. And the utilities will want to avoid that delay and any cascading delay by getting it right the first time. That's true under either of our views here, and I think it has no bearing on the right interpretation of the rule or of the statute in this proceeding. Finally, the General Assembly's most recent amendment to Section 62-133.2D confirms that the Commission's approach is consistent with legislative intent. In SB 266, the 2025 General Assembly amended Section 62-133.2D to remove the phrase "during the test period," the 4 words on which the public staff rests its entire argument. As the public staff accepts, the current version of Section 62-133.2D allows the Commission to consider over or under recoveries that are experienced during the test period, regardless of when the fuel costs were prudently incurred.
Well, what was the need for this amendment if it was clear and right? And that's my question: is
Sure.
why would the General Assembly feel a need to do that if they were not changing the law?
Yeah, so two points in response, Your Honor. The need, I think we can look back to this court's and the General Assembly's experience in Thornburg for the need, right? This is a sort of like Thornburg in reverse. In Thornburg, the General Assembly came in after the decision and disagreed with this court's decision and made clear and clarified that the law had always meant what the Commission thought in that proceeding. Of course, here the Commission, we think, got it right, as it did then, but there was an appeal pending. The amendment was made among a host of other changes. It's not as if they acted only to do this. And while this appeal was pending, they clarified the law. Now, my friend says that they titled that a modification, and that is, of course, true. But the reason for that is that they did not just make a change just right during the test period. There's a host of other changes to fuel rider proceedings that was made in SB 266, and those were modifications to the law, including like the categories of fuel costs that can be included and considered in a fuel rider proceeding. And so I think there's a good reason for it to call it a modification, but this court, the Supreme Court, has recognized, in Farrell in particular, that even when an amendment is partially clarifying and partially altering, the clarifying aspect of the amendment can be and should be considered in construing the prior version.
Isn't that kind of how it works? We get a court case, and down the street they go clarify the law. I mean,
It's certainly not uncommon, and I think what the Supreme Court has said in Ray and in Farrell and a number of other cases, that when that amendment is a clarifying one, and there's 2 indicators here that I think make this a clarifying one, it should be considered in construing the prior version. The 2 indicators that the Supreme Court has discussed is, 1, if there's an ambiguity in the prior law, then an amendment that removes that ambiguity should be seen as clarifying. Here, to be clear, we think that we've got the better of the plain text of section 62-133.2D, but if, at a minimum, it's at least ambiguous on the question, and the new amendment is not. And so I think it should be looked at in construing the prior version. The other is if a law doesn't address a particular issue and a subsequent amendment does, that too should be seen as a clarifying law that can then be looked at when construing the prior version. Same thing here. We think we have the best reading of the plain text. But again, at a minimum, it doesn't say in express words, doesn't answer the question, which is why we're here today. The subsequent amendment can't be understood as to do anything other than resolve the question presented here. And so we think it should be seen as clarifying and helpful in construing the prior version.
Well, let's pretend we're in an alternate universe and I care about the policy behind these. What is your client going down to the General Assembly and saying this is good policy for?
I don't think it's actually close on the equities here, Your Honor. What we are trying to do is to account dollar for dollar for fuel costs. These are costs that, as I said at the top, are things that we largely can't control. And of course, in order for us to recover for them at all, they have to be prudently incurred. And our approach makes sure that we get for every dollar of prudently incurred and reasonably incurred fuel costs, $1 of recovery, no more and no less. So we are here, of course, because there was an under recovery. And so an unprecedented under recovery, and we're trying to, the commission, we think, properly allowed us to account for that under recovery of something like $17 million. But it makes no difference if it went the other way, right? If we had a $17 million over recovery, what we're trying to do is that and what the commission is trying to do is ensure that we only get recovery of those fuel costs that were prudently incurred. So if it's a $17 million over recovery, then that goes back to consumers, and it goes back to consumers with interest. Now the public staff has pointed out, of course, that we haven't done this in the past. We haven't sought to account for over recoveries or under recoveries in the past, and the commission hasn't adopted the statutory interpretation that it adopted here in previous proceedings. I'd say a couple things about that. First, if you look at that chart from the past 10 years, that has not gone to our benefit, right? DEP and DEC both net under recovered something like $2.5 million over the past 10 years. But I take the point to be that everybody before, for 30 years, has thought the rule was one thing, and now we're saying it's something else. But I don't think that is an accurate view of the history. In fact, in the past, although Duke hasn't asked to account for these under recoveries, that's not because we made a determination that we couldn't. It's because the issue just wasn't focused on before the unprecedented under recoveries in this case. In the past, those were de minimis under recoveries against the grand scheme of the fuel costs in any proceeding. When this issue came up, we looked at it closely and we reached the conclusion that we did. And the history with the commission is very similar. Again, they haven't adopted the contrary view for 30 years. Instead, it's come up only even indirectly twice as far as we can tell. Once is in 2014, we talk about this example in our brief, when the commission allowed another utility to collect an under recovery over 2 billing cycles with a final true up at the end. It adopted that approach, the one that we're advocating for here, with the public staff's approval. The other time that it came up, though it's not discussed in the brief, it's in the record, is in 2003 when an intervener proposed a, quote, true up of a true up. And the commission declined to reach the legality of that view because it ultimately didn't take the position. But I think what that shows is that the commission has never adopted a contrary view. It just hasn't focused on the issue until these proceedings based on the unprecedented under recovery that's at issue here. Now, public staff argues that the commission's approach in the orders here is simply inconsistent with the nature of rate making. I said that in the briefs and again this morning. Rate making, the public staff says, is a forward-looking endeavor. Correcting for under recoveries and over recoveries thus violates the judicial presumption against retroactive rate making. That's the argument that they advanced and won on in Thornburg. But the General Assembly disagreed. When the General Assembly amended section 62-133.2 to clarify the law after Thornburg, it made clear that what the commission had already recognized, that riders are different than base rates. Rider proceedings are different than general rate cases. Unlike general rate cases, rider proceedings are both forward-looking and backward-looking, and the fuel rider in particular is designed to correct for and eliminate any over or under recovery of fuel costs. And that's all the commission is trying to do here. Public staff argues finally that the Commission's approach in these proceedings is impractical, based on their fear that it could lead to an endless series of true-ups of true-ups. That practical concern, though, in our view, is misplaced and irrelevant. In only the most extraordinary cases will it require more than 2 billing periods to recoup any under-recovered fuel costs. That's so because going forward, the utility will use fuel rider proceeds to pay off and repay the oldest fuel costs first. So after 2 billing periods, then, the oldest fuel costs will be collected and recovered dollar for dollar, no more and no less. The Commission can then move on. In any event, to the extent that the public staff has any practical concern about the Commission's approach, it's clear that the General Assembly does not. The General Assembly, as we've discussed this morning, and as the public staff accepts, has endorsed the Commission's approach. So any practical concerns that might exist should not give the court any pause in adopting that same approach here. In short, the Commission's interpretation of Section 62-133.2 is most consistent with its plain text, most consistent with its context and history, and is, in our view, a faithful implementation of the General Assembly's intent reflected in Section 2 of the 1987 Amendment and the most recent amendment in SB 266. The Commission's interpretation is fair and a sensible policy for North Carolina utilities and for North Carolina consumers. The court should affirm that interpretation and the Commission's orders.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. If I could address, please, some of the arguments counsel made and then get to your point about this retroactive application. Thornburg is still good law. The Thornburg court issued a decision and the legislature read it and acted accordingly. They changed the law. Thornburg said, if you want to make something clear, make it clear. They said, okay, we'll make it clear. Here we go. Thornburg was not overruled by the General Assembly. The General Assembly responded to Thornburg, if the difference there. DEP had a $9.2 million, was faced with a $444.8 million under recovery and collected all but $9.2 million. So what's that, like 2-3%? A lot of life-changing money for me and you, a few percent here. Same for DEC, $998 million under recovery, net $17 million off. Again, what? I'm doing math from the podium, but 2%. So they were given an opportunity to recover, and they didn't get it. Had in the years when they had over-earned millions, had they come in and said, gosh, we got a couple million, we got $5 million, we got $2 million, we should give that back to customers, I would have a little more faith in the, well, it was just a small amount, and we knew we had this right, but we didn't tell anybody for decades. It undercuts the arguments. To speak to, and I think textual indicators was how it was referred to, some of the textual indicators that, in Duke Energy's opinion, mitigate against the public staff's understanding. The first one was this incorporate language, and in the statute, what's being incorporated are the fuel costs incurred during the test period. The second argument was this 30-day update, which counsel spent a few minutes discussing. It's the very next sentence in this statute, and it's an early bite at the apple. In addition to the fuel costs incurred during the test period, the Commission shall, quote, also incorporate in this determination, quote, fuel costs incurred after the test period. So there is a time limitation. For DEC, it's the fuel costs incurred from January 1st through the date that is 30 calendar days prior to the hearing. It'd be April 1st for DEP. And remember, we can't do a correct true-up until we've audited the actual costs, which happen in the next proceeding, right? The public staff takes issue with costs, fuel costs all the time. And so the actual fuel costs, which are the basis for the comparison, forecast to actual, we don't have the actuals because the audit hasn't happened yet. That's why the next sentence isn't really applicable here. And just as a factual matter, these were computed in a acceptable manner This was not, it was not used by Duke Energy as a vehicle for truing up all the fuel costs. You can look at the transcript for DEC at page 225 and the transcript for DEP at page 95. DEC put in January, February, and March's with a $25 million under recovery, and DEP put in April, May, and June's fuel costs for $49 million under recovery. In the year after, the public staff would audit those fuel costs, and that's when the true-up of the incurred during the test periods can occur. And I think council alluded to this, but Section 2 was really the focus of the commission, not this sentence. One of the other sentences referenced in subsection D of the fuel rider statute was this sort of efficient management concept. And this section shouldn't have a temporal limitation. It relates to the entire fuel rider. The forecast, the true up, these little 30-day, up to 30 days before, that's why the statute uses the broad term adjustment. And this is a further clarification of what constitutes reasonable and prudent fuel costs. They have to be incurred under efficient management and economic operations. So this would prevent Duke Energy from choosing to operate on a temperate day when there's not a great demand for power. Duke Energy could operate either it's inexpensive to operate a nuclear plant or it's far more expensive to operate coal plant. Well, why not operate the coal plant? Yeah, you needed that coal. Yeah, it was prudent to use that much coal, but it's not an efficient, let me quote the statute, it's not incurred under efficient management and economic operations. That's what that law is getting to, is how you run the stack. One of the other points was pointing to the Commission Rule R855. I just think we look at the same thing, and I say the phrase during the test period modifies fuel costs and fuel revenues. It's got a very similar structure. A couple of points there. First, the statute controls always. This is a commission rule. And second, again, the commission really kind of looked to Section 2 more than its own rules. This idea that Section 2 is sort of super law and just trumps everything. Session law is neither more or less than any other law. It's law, but it doesn't beat the other laws back. It's the same as if this had been enacted and given a subsection Z denotation, fine. We would have been, that's still the law. The cases cited are where things were left out, right? The session law controls the text of the law. If you leave out a colon, yeah, we're going to go back to the session law, put it in. If you forget to put in a temporary provision, yeah, the session law is going to control. If you go, they left out a whole hit and run section in one of the cases cited by Duke Energy, and they said, yeah, it was in the session law. It should have been in the code. It doesn't just overwhelm all the other laws.
Is there anything analogous to your interpretation versus friend on the other side? I mean, you know, they're saying this is dollar for dollar, you know, whoever comes up or down, like this is going to be even. Like, is there anything analogous to your interpretation that says, you know, there might be a $2.5 million gap or plus or minus on either side? Like, is that, it just doesn't seem consistent with any other law I've seen. Like,
well, a couple of points. Section 2, in pointing back to that 1986 order so clearly and directly, it's really, I said it was one sentence, I guess it's really like 12 pages, right? It's that whole order dumped into the law in a sense. They're saying the commission got it right there. And so that commission said, it sort of envisioned these swells of over and under recovery. And, you know, we got zillions of dollars, lots of power, how things go. It's, rate making is always kind of an over under recovery. So
I guess I'll ask you the same question and ask Mr. Ellis, you know, if I cared about policy, what is your argument to the policymakers that your interpretation is what they intended?
I think it's a policy call for how fuel costs are recovered. Are they recovered in the traditional manner or in a dollar for dollar scenario? And in 1987, it was the traditional manner, sort of this forecast and one-time. Well, before 1987, it was the traditional manner, forecast. And then in 1987, it became forecast with a one-year true-up. And then in 2025, legislature said, no, let's do dollar for dollar. let's do a straight up for dollar, and they made it very clear by removing that limitation, that during the test period language, incurred during the test period language. So I think the policy has evolved. It used to be more risk on the company, and then the legislature said less risk, and then no risk, which, again, these are all policy calls. There's no right or wrong answer. It's just a policy decision. And I want to make sure I address the court's.
Yeah, I mean, you acknowledge and concede that they've changed or clarified the law.
I would say
modified under your posture, yeah.
The Dominion case was referenced. In the Dominion case, the rules were set ahead of time. There was a settlement brought to the commission by the utility. The public staff agreed with it. The commission agreed with it, and they accepted it ahead of time. They set the rules ahead of time, and that's what rate making is. We'll set the rules, and then we'll follow them. That's prospective rate making. You can set the rules that we're going to true up in 2 years, fine. It's when you come back after the fact and say, I know what the rules were when we started, but I'd like to change them now because I'm financially impacted by them. That's when we get into that impermissible retroactive rate making, the sort of general ban, unless you've got a very unambiguous and manifest statement by the General Assembly to the contrary. Apologies, Your Honors. I want to make sure I touch on all those points. I do think that the 1986 Commission's opinion that foresaw decades of over and under recovery kind of gradually evening out. I think the word used by counsel was $2.5 million over 10 years. That's a remarkably close to zero number when you consider the magnitude of the zillions of dollars flowing through this fuel rider. I think if you say that DEP and DEC had de minimis amounts when they over-recovered by $2 and $5 million, and therefore that's why they didn't come before the commission and offer an over-recovery. $2.5 million over 10 years is a de minimis amount and pretty close to zero for rate-making purposes. And let me just speak to the retroactive application. If we carry to its logical conclusion, that retroactive application, why not go back to 1987 and get every penny of fuel costs from when the legislature created the law until today? And until July 2025, there was a 10%, up to 10% interest added onto over-collections of Duke Energy. And so I think if we did the 10% interest and went back to 1987, it would be a massive tsunami. I just cannot imagine the legislature intended that. Why not go back to 2019 and pick up some of these $5 million over recoveries for customers? When do we start the clock? And once you get into when do we start the clock, why not just follow statutory construction? We'll start the clock July 29th, 2025. That's when the fuel costs went from having the 1 year incurred during the test period limitation and became incurred. That's a great starting point. It's the starting. Hicks says start. Don't go retroactive unless you've got a clear intent expressed by the legislature to the contrary. Just in the last few minutes, and we argued these again at the fuel rider proceeding for DEP after the ones under appeal. The Estridge versus Ford Motor case, and these are not briefs, so I don't know how much detail the court wants me to get into them, but...
Well, you've got a minute and a half, so...
Yeah, I'm glad that all these cases are when these things arise, vest, manifest, become substantial before the law, you don't need to have a retroactive application. Fuel costs are reported to the dollar every month to the commission, to the dollar. And so we know what they are well ahead of time. I think we just say, hey, the law started on July 29th. That's when this new policy came down from the legislature. We're not going to have this 1 year limitation. From now on, it's dollar for dollar, rolling recovery, true up to the penny. That policy call's been made. It shouldn't be retroactive because the fuel costs were real, paid, incurred, substantial, vested, manifest, all the words of the case law. Once a right or obligation becomes more obligated, more real, then you don't have this retroactive application. I would reiterate our request that it be reversed and remanded, and I'm glad to answer any questions the court may have in the short time remaining.
Thank you both for excellent arguments. And court will be at ease for a few moments while we reconfigure the courtroom and also work on what we have to do to redo the streaming service that I don't understand, but they do. So we'll be at ease for a few moments.